Good evening. I'm Harshita Akkar, intern at Indian National Bar Association, a student of fourth year BBA LLB at School of Law, Christ University, and I'm in conversation with Advocate Tariq Khan, Principal Associate Advani Co, Barristers-At-Law, New Delhi. Sir has authored various books and articles and was also appointed as a secretary to the Arbitral Tribunal for a SIAC arbitration. He specializes in IBC, arbitration, and MSME disputes, and so has agreed to share his eminence with us on his favorite topic of arbitration. We welcome you, sir.
Thank you, Arshita.
So first off, I would like to begin with one of the questions, that is, it is an unproved assumption backed by anecdotal evidence that there still exists certain kind of resistance to arbitration in India when compared with other jurisdictions. I believe it would therefore be fruitful if we could discuss about what are these resistance actually and how are the tribunals dealing with such kind of resistances.
Interesting question, Harshita, which you've asked. I think that it is very, very common in the Indian jurisdiction for parties to first agree to arbitration while entering into any kind of commercial contract. And subsequently, when the claimant invokes that arbitration clause, the parties generally have a habit of resisting the arbitration. There are various grounds on which the parties resist arbitration, most common being the one which is anti-arbitration injunction. We have seen in recent cases, I'll give you an example. As you are aware that since Balco judgment was given, the reputation of the Indian courts, the approach of the Indian courts towards the arbitration was being considered as pro-arbitration stance. But with the judgment in the case of McDonald's, Vikram Bakshi versus McDonald's, wherein I think the Delhi High Court passed an arbitration injunction when the arbitration was going on in London. And very recently, I mean, last year, I think in Vodafone case, the same kind of order was given. On the very first day, the injunction was passed. So I think it was a BIT in that case. But I think only very recently, in the case of Beena Modi versus Lalit Modi, the Honorable Delhi High Court, Justice Endlaw, was kind enough not to grant that kind of injunction. And I think it was a very positive step, because we need to give a very positive signal to the international community and various other jurisdictions that the courts in India do not appreciate any party taking steps which are in fact, which would result in resisting arbitration as a practice. Apart from that, what we have seen is that parties have a habit, like when a claimant will approach the court for appointment of an arbitrator under Section 11, ideally it should not be disputed because it is a very simple matter. It is only for the purpose of appointing an arbitrator. However, what we have seen is that Section 11s are being disputed on various issues. For instance, the issue of arbitrability, the issue of fraud being alleged because fraud is not arbitrable. Then people say that the subject matter is not arbitrable, there is no dispute, or else they will object on the ground that sufficient stamp duty has not been paid, on the agreement. And other common objections including, for instance, that there was no valid arbitration agreement entered into between parties. Though these objections, for instance, with respect to the jurisdiction of the tribunal, can be taken before the arbitral tribunal. However, it is a practice, as we see, that these objections are being taken in court, which eventually resist the arbitration and in fact delay the arbitration process, and which, in my view, defeats the very purpose of arbitration, which is the speedy resolution of disputes. So I think that's a major problem, why parties who initially agreed for arbitration, later on they have issues.
My next question would be somewhat linked to the previous one, that there is no doubt that Singapore courts have adopted a very pro-arbitration approach, which is aimed at protecting the sanctity of the arbitral award, as well as the tribunal's jurisdiction and facilitating the process of arbitration. And that is one major reason why Singapore is also known as the arbitration hub of Asia. What changes would you suggest in the Indian arbitration to regard competence to our competitors in Singapore?
Okay, so you want to know my views as to how we can become like other jurisdictions like Singapore. Is that what you're asking?
Precisely.
Perfect. So if you've given me an excellent example of Singapore, I mean, the courts in Singapore have been very, very arbitration friendly. They've taken a very positive step. Even in relation to enforcement of foreign awards, they have been very lenient. They have not interfered much. They have, in fact, narrowed down the scope of public policy. And I'll give you an example of the award, the very recent one, which is in the Daiichi matter, where we saw that the Supreme Court of Singapore did not entertain the challenge and it was set aside, thereby making the award enforceable. So I think similar practices need to be adopted. We must reflect and we must give a message that we are taking a positive step. So I'll give you an example of recent Supreme Court judgment in the case of Nefed versus Alimenta, where, in my view, a regressive approach has been adopted. I think the award was not enforced. So, I mean, such kind of judgments which are being passed, because a foreign award as compared to the domestic award is not open to scrutiny. In fact, if you read the language of Section 34, it clearly says in the Indian Arbitration Act that the patent illegality will not be a ground for setting aside an international arbitration award, which is a foreign award. It is only a defense available for setting aside a domestic arbitration award. So the intention of the legislature is that you do not interfere with the foreign awards much. The threshold is much, much lesser, and as compared to the domestic arbitration. So, two things. Firstly, with respect to challenges, and secondly, with respect to enforcement. I think courts need to send a very positive message. I think that is the only way how we can, in fact, compete with jurisdictions like Singapore and other jurisdictions which are, in fact, quite popular and are considered as hub of arbitration in the world.
On that very note, I would want to ask my next question based on the practical aspect of arbitration. So it is often seen that defining confidentiality in arbitration is not a problem, but the real problem lies in defining the duty as to who has to maintain this confidentiality. I would not be incorrect if I state that one of the major reasons why parties come for ADR resolutions, especially arbitration, is that because the matters are of a private nature which cannot be discussed in an open court. So we would therefore like to know your views upon how to establish this duty. And would I be incorrect if I deduce to the logic that confidentiality, after all, is a myth in arbitration?
Excellent question. I completely agree with you. I'll come to the second part of the question later. I'll start by telling you initially about the provision for confidentiality. So, under the previous act, under the Act of 1996, originally there was no provision for confidentiality. There was only Section 75, which I think applies only on conciliation proceedings, and it does not apply on arbitration, which are being governed by Part 1 of the Act, the domestic arbitrations. In my view, when the Sri Krishna Committee was appointed after the 2015 amendment, which came on 23rd October 2015, and there was still a need felt for making certain improvements in the Act of 1996, and that is when Justice Sri Krishna Committee, they realized that there is no provision as such for maintaining the confidentiality of the arbitral record of the documents which are subject matter of the arbitration. And thus, they realized that the provision 75 is not applying to arbitrations as such. Therefore, in the amendments of 2019, which recently were introduced, there is a provision which has been now introduced, which is 42A. In my view, it has not been notified so far. But 42A, what basically it says that you asked about whose duty it is to protect. So the arbitral record essentially is going to be available with the parties, with the arbitrator, or with the arbitral institutions. So in my view, the language which has been used is that the arbitrator and the arbitral institution shall protect the confidentiality and shall not publish or share the information of the arbitration in the public, except the award, which may only be required for the limited purpose of setting aside or for the enforcement purpose. So I think that's the provision which is now used, that these proceedings are in fact become confidential, because rightly said by you, that is the beauty of arbitrations, because corporations do not want that the dispute should come in the public, because it in a way affects their goodwill and reputation. Now, coming to the next part of your question, that confidentiality is a myth. I completely agree with you. I completely second you on this. Though there is a provision now, and the suggestion which I would be giving would not have much significance. But in my view, because the arbitral record at the end of the day, when a party challenges an award, goes to 34, and before the court of law, it is challenged, then in a way, everything is in the public, because the proceedings are taking place in public. The counsels are arguing the matter in the open court, and the name of the parties, the contract, all the details are coming out. And eventually, when a judgment is passed and you see the detailed facts, you see the issues which were involved. So I don't think anything remains confidential. In my view, it would have been better if we do away with confidentiality and if we start publishing the awards. In my view, the most important purpose that it will serve is it will make arbitration more credible and fairness will be ensured. Because why a party trusts a judge who's sitting in an open court? Because everything is happening, there's a transparency. Whereas in an arbitration, if the arbitrator has a feeling that whatever I am doing is only going to be confined to this limited room, then in that case, the arbitrator may not ensure quality, and in some cases, the credibility may not be there. So, if the arbitrator knows that my award will be published and it will go in the public domain, then in my view, the quality of the awards will improve, and there'll be too much of literature also for a lot of people to go through it, for students, for academicians, because I think such beautiful awards are written, and they will in fact help us in we can make an archive, we can make a record of our own. So yeah, I think that's one thing which I believe should have been done away with. But anyway, it is what it is.
Those are very forward-looking points. Taking inference from the judgments provided behind the closed doors in an arbitration award, I would want to raise the point of arbitral immunity. Arbitral immunity is a well-established principle in international arbitration, which was basically aimed at saving the arbitrators from frivolous lawsuits by dissatisfied parties. However, this immunity is not absolute and does not absolve them of their ethical duties towards the parties. Could you throw some light on the procedure for filing claims against arbitrators when they breach their ethical duties?
That's an interesting question. I'd like to tell you initially that with the advent of arbitration culture in the country, I'll only give you an example of India. India is not a jurisdiction which provides any procedure for taking action against an arbitrator. There are countries, I think Dubai, for instance, has some provision, and there are countries which are in fact providing provisions, and there are acts wherein arbitrators can be subject matter of the proceedings if there is fraud or corruption involved. I'd like to tell you that initially, before the 2019 amendment, the arbitrators were being made party to the proceedings. So whenever an award was challenged, especially in the lower courts, what I had seen, arbitrators were being made as a respondent in that matter. And there were certain allegations sometimes made against the arbitrator. Due to this reason, the Sri Krishna Committee again thought that there is a need to protect arbitrators, and there should be some provision under the Act which will make the arbitrators immune from these challenges, from these legal proceedings and suits against the arbitrators. Because you know how it happens, a dissatisfied, a losing party may end up going to any limit. So to protect them from that, there's a provision which has now been introduced. It is 42B of the amended Act of 2019, wherein it is said that no suit or legal proceeding can be filed against an arbitrator. And this kind of immunity like the judges of the courts enjoy. Similarly, the arbitrators are also being given. This is a civil immunity in my view. And only the language which has been used is if they are acting fairly, if they are doing acts which are very fair. So in my view, this is slightly ambiguous because it doesn't say that what will happen if the arbitrator has not acted fairly. It does not refer to the repercussions. It does not talk about the consequences. Issues can come up and what all actions can be taken against the arbitrator. Having said that, I feel that it is good in a way, such kind of immunity, if you look at the positive side, because the arbitrator can be free and he would be under an impression that, look, I can work with a free mind. Because, if this immunity is not given, many people will perhaps not take up the role of arbitrator, and we will perhaps be deprived of some amazing arbitrators because they'll have the fear that what if I'm acting fairly also and the losing party take me to some extent. So, I think it's a very good provision, but we'll have to see at the end of the day how it is implemented and how it turns out to be.
That being said about the arbitral immunity, I would like to take the course forward by bringing the notice to another important, significant aspect why parties choose arbitration. That is that even if not for settlement, an award will be rendered at the end of the arbitral process. This end product, I would say, is of the utmost importance to the parties. What, in your belief, should be a general set of norms of a sound legal framework for recognition and enforcement of these awards?
I think that, like you rightly said, see it at the end of the day, it all depends on arbitration, how it is being enforced, and how the arbitral awards are going to meet the end of the day, and at the end of the day, how the winning party is going to get the fruits of the award. So enforcement, in my view, is a very, very important aspect. So speaking for the scenario which is currently there in India, like I said, the recent judgments of, for instance, I give you an example of Nefed Alimenta. The approach was regressive in my view, and I think we need to send positive message. The procedure for enforcement must be, very. I must say that the interpretation of the public policy word, because an award is set aside and not enforced if it's against the public policy, etc. It should be narrowed down. We should not interpret the term public policy widely. We must not entertain challenges to some extent, and the idea is to not refuse enforcement of these awards and send a very positive signal, like I said while answering your first question. And there should also be some time limit for enforcement of these awards, because at times there are. I mean, I don't think there's any fixed time limit which has been given to enforce the foreign awards. But it would have actually been a very nice thing if some provision could have been introduced that there'll be a time limit for enforcement of a foreign award. Because at the end of the day, any corporation in the commercial world, parties would always want their money to get back to them at the earliest. So sometimes when they are winning an award, they are waiting for years for the enforcement. Like we saw an example in Daiichi matter, enforcement took some time. So in my view, I think there should be some fast track provision, and I think that would really help the purpose.
My next question would be in light of the current scenario of COVID-19. In your belief, is there any foreseeable impact of COVID-19 on the arbitration transactions, both at domestic as well as international level? Also, are there any suggestive changes that the arbitration clause in various contracts should undergo to sustain validity in such times?
I'll take your second question first, which talks about the changes in the arbitration clause. One very important aspect which I'd like to highlight, and I don't think many people would care about this. In a lot of jurisdiction, virtual hearings are not considered to be fair hearing. It's not considered to be a proper mode of hearing. And thus, sometimes what happens is when these hearings happen, the other party can challenge it. And it can say that, it was the right to fair hearing was violated by the tribunal, and the party was not able to present his case or her case properly before the tribunal. The other aspect that they can raise is that principles of natural justice have not been followed, and this can be one objection. Therefore, when you are now drafting your arbitration clause, and since you know that there are going to be virtual hearings only for some time at least until we get a vaccine for COVID, I feel that we must incorporate in our arbitration clauses one line which will say that virtual hearings will be acceptable by both the parties as proper hearings or as a fair way of conducting proceedings. Something on those lines, which will then eventually help you in restraining the other party from raising such objections, such technical objections at the stage of setting aside or at the stage of enforcement. On the other hand, the impact of COVID on arbitration, I think we must take it as a very positive step. We must feel that arbitration has evolved from time to time. Few years ago, we were not aware about emergency arbitration or the timeline of 1 year for passing of an award, but it was introduced, and it was actually a very positive step. So I think if we look at the positive side, it would be that now parties do not have to travel worldwide just to attend arbitration. Sometimes the arbitrators were coming from London, the witnesses were coming from Italy, Singapore, etc. And now, since that all of us can sit at the comfort of home or office, and if at all we are virtually well equipped, we have a decent infrastructure that way, then in that case, we can attend the hearings without any kind of issue. And I think we should take it as a development rather than any issue with the arbitration, though it is a necessity and none of us was prepared for it. But I think in the times to come, it will eventually make it very convenient. The only issue that I see is that where the arbitrations where the record is very voluminous, and especially during a cross examination, the cross examiner may face various issues because sometimes you have to refer to various documents at the same time, or you need the assistance of your junior to help you with the documents who will not be there, or even if they are there, then you do not see the gesture of the witness. I think all of that may make some difference, but wherever possible, I think virtual hearing is a very positive step.
That's a very progressive thought. In fact, you touched upon the virtual hearing aspect, and my next question relates to the virtual hearing in detail. So, considering the fact that litigation has resorted to online means in the form of virtual hearing, do you believe that virtual hearings in arbitration are going to be as efficient and as fruitful in the virtual aspect as in the physical setup. This is in light of the interpersonal skills that are required by the arbitrators to establish empathy with their parties. Is it possible on a technology based communication?
I think it is possible because the way that, I mean, I have delivered a lot of webinars, and now that we are getting accustomed to this new thing, it's a new normal, virtual hearings. So, I mean, initially, yes, it is slightly difficult. We are taking time to get comfortable with this. But I think once we get comfortable, there'll hardly be any issue. Like, for instance, I'm in an interview with you right now. I'm not feeling as if you are not, even if you were sitting right here in front of me, it would not have made much difference. So I think once you become comfortable with technology, I think it would not make much difference. But like I said, the gesture of the witness and all these things which the tribunal has to observe during the evidence, I think only that part may be compromised.
Finally, on a lighter note, how would you sum up your regular Monday morning at a firm, and how have you adopted to this new model of work from home?
So I feel that much has changed. A lot has changed now after the COVID, especially since none of us was prepared for it. We were not very well equipped. And earlier Monday mornings were typical Monday morning would be getting up early in the morning, going to court, switching from one court to another, running from one courtroom to another courtroom. And at that time, Mondays, we did not like much. We were very upset with Mondays that, it's a Monday. We were not pretty happy. But, and then coming back to office, of course, and working till late in the wee hours of the morning sometimes. But now much has changed. We are working from home. We have, in fact, made workstation at home. We go to office only if it's extremely important to get some files or some documents. And Monday doesn't feel the same anymore. So I'm saying I think work is suffering quite a lot because of this. And now all days are the same. There's no Monday, there's no Sunday as such. And I think one must try to stay productive. At the end of the day, it is up to you how you take this COVID, whether you take it as an excuse for not working, or you make the most out of it, because now that you are home, you are saving on a lot of time. You're not going out, you're not traveling, you're not stuck in Delhi traffic. So I think those are the things. And especially the good part is that now you don't have to wait the whole day for one matter in the court. So now the way things are happening, I feel that slots are being given and matters are being taken up accordingly. So you just have to see when your matter is going to come up, and you can just log in from your phone and enter the Zoom ID or Cisco ID, where you can just appear before the court. Earlier, you used to be in the court the whole day, you would not know whether a matter will come up or not. So I think a lot of time can be saved that way.
I think on that note, I'm going to put an end to this session. It was wonderful having conversation with Advocate Tariq Khan, and I hope the viewers enjoyed it as much as I did. Thank you so much for your time, sir.
Thank you, Harshita. It was my pleasure.